Hello, friends. This is Dr. Shashi Agarwal. I welcome you all. Today, our subject is Business Law 1, and the topic is meaning of contract, or we could say what is the nature of the contract. This topic is relevant for the student of BCom first semester and also relevant for the student of BBA third semester. If you find my video useful, please do like it and share it, and also subscribe my channel Shashi Agarwal. This video is also available in Hindi at my second channel Shashi Agarwal Economics and Law Classes. I will share the link in the description box. So this is my app, Adusum app, which could be downloaded from the Google Play Store. This app is relevant for commerce, economics, and management. It provides free study material as well as many mock tests to the commerce, economics, and management students. It also offers many structured courses. Business Law 1 is also available at my app in the form of structure course. Today we are going to understand the meaning of the contract, or we could say the nature of the contract. First of all, what is the meaning of contract? So, contract in agreement. Contract is an agreement. Agreement means when the one party makes an offer to the other party and the other party accepts it. So, contract is an agreement to do an act or not to do an act, and the it should be legally binding agreement. Legally binding agreement which is enforceable by law. So, contract is an agreement which is legally binding agreement, which is enforceable by law. It means when one party reach the terms and conditions of the contract, the other party has legal remedy. It could that party could go to the court and sue the other party who has reached the terms and conditions of the contract. Contract is an agreement which is made between two or more parties, which the law will enforce. According to Solomon, contract is agreement create and define obligation between the parties. That Frederick Pollock says every agreement and promise enforceable at law is a contract. Section 2H of the Contract Act 1872 defines an agreement which is enforceable by law. So, contract means an agreement. And the second thing is it should be legally enforceable by law. So, what are the essentials of the contract? It should be an agreement. The one party should make an offer, the other party should accept it. And the second thing is the parties they should have the intention to create the legal relationship. So, it should be enforceable at law. So, contract is an agreement plus enforceability of law. Contract is an accepted proposal that is fully understood by the law, is legally enforceable by the law. Here, it is accepted proposal means one one party A makes an offer to B and B accept it. Then it becomes the accepted proposal. And here, the parties A and B they should have the intention to create the legal relationship. The contract should be legally enforceable by law. If one of the party makes a breach of the contract, the other party has legal remedy. So contract is an agreement. Agreement is a promise. Promise when it is accepted, then it becomes proposal. And that proposal, when the parties they have intention to create the create legal relationship, it is legally enforceable, then it becomes contract. So we could say contract is an agreement. Plus, it should be enforceable by law. If it is not enforceable by law, then it cannot be contract. Now we will understand what is the meaning of agreement. Defining section 2E, every promise or every set of promise forming the consideration for each other. Like here, A want to sell Maruti car 1988 model for 50,000. So this is the offer. So this is the offer which is made to B. Yes, I am ready to buy your red Maruti car 88 model for rupees 50,000. So when B accepted, then it becomes the agreement. Here A makes a promise to sell his car for rupees 50,000, and in return he will get 50,000. He will pay 50,000 to A, and in return he will get car. So agreement means every promise, every set of promise forming the constitution for each other. Promise means two subsection B. Proposal, when it is accepted, then it becomes a promise. An agreement involves the one party makes the offer or proposal to the other party, and the other party accept it, then it becomes an agreement. So, for creating an agreement, we require the existence of two or more persons. There should be plurality of person. A person cannot enter into agreement with himself. So agreement also means the party have a common intention about the subject matter of their agreement. It means the both the party they should understand the subject matter in the same sense in this at the same time. Two parties should be thinking of the same thing in the same sense at the same time. Agreement is the outcome of two consenting minds. It is also called consensus item. Consensus item means when both the party they understand and interpret the subject matter in the same sense. Like I want to sell my red Maruti car, but the other party thinks that I'm selling my steam car, which is also in red color. So here the mind differ. So it will not be an agreement. The agreement will be there when there is a consensus add item. So agreement is equal to offer, and second thing is acceptance. So agreement means proposal when one party makes an offer to the other party. When the other party accepts the proposal, then it becomes proposal, a promise. When both of the party agree to promise for a consideration, it becomes an agreement. Finally, the agreement should have the enforceable or enforceability of law. Then it becomes the lawful contract. A offer to paint a picture of B if B gives him rupees 200. So A is making an offer to B and B said, yes, you make a picture of me, I will give you 200. So this is the acceptance. Here it becomes the agreement. If the intention is to create the legal relationship, then it becomes a contract. So the agreement should be enforceable by law. An agreement to become contract must give rise to legal obligation. If there is no legal obligation, then it cannot be contract. Legal relations should be there, not domestic and social. Agreement is a wider term. Every contract is an agreement, but every agreement is not contract. So agreement is a wider term. It also includes domestic and social agreement. Like Ram invites Sham for dinner, but Sham goes to Ram's house and Ram is not available. So Sham cannot go to the court because it's a social agreement. It is not a contract. Here the party they do not have any intention to create legal relationship. Balofar versus Balofar is a famous case. Mr. Balofar was employed in Ceylon. His wife, Mrs. Balofar, due to ill health, has to stay in England. She could not accompany him to Ceylon. So Mr. Balofar promised to send her pound 30 per month while he was abroad. But Mr. Balofar failed to pay that amount. So Mrs. Balofar went to the court, filed a suit against her husband. The court held it is a domestic agreement. Here, that is the domestic agreement between the husband and wife, and the both do not have an intention to create the legal relationship. It is no contract. So Mrs. Balofar have no remedy. So contract is agreement and it should be legally enforceable. All contract are agreement, but all agreement are not contract. It's a very significant question which we will be understanding in the next video. For making the contract, there should be at least two parties. One party makes an offer, the other party accepts it. And there should be intention to create the legal relationship. If the legal relationship is not created, then it will not be called a contract. So, under the contract, these are the rights which are available to the parties, right in RAM or just in RAM. As per the law of India, every person entering into a contract has right in RAM. This right is available to everyone. So, this right is available to him or her against the entire world. It protects a person's property from the entire world. Like Mr. A, Mr. X has purchased a house. So this house exclusively belonged to Mr. X. So no one have the right to disturb his right. So he has a right in wrong with respect to his house. Right in personam or just in personam, this is the opposite of right in wrong. Right in personam gives the person right against one person or party to the contract. So here the right is available to the persons who are party to the contract. If one party breach the terms and condition, so the other party has a right to sue that person. The Indian Contract Act grant right in personam to the parties of the contract. This right is only available to the parties of contract. So the parties of contract have these contractual right against each other. That is just in personam. In the next video, we are going to understand the essentials of a valid contract.